This episode was produced by Bach Pro Se. Run your own legal research at prose.trybach.com.
Picture this. You're at home in Broward County. Maybe you're just finishing dinner, trying to unwind after a really long day.
Right.
And suddenly, there is this heavy knock on your front door. You open it, and standing there is a deputy from the Broward Sheriff's Office. Or, maybe a certified process server holding a clipboard.
Always a stressful moment.
Yeah, exactly. They confirm your identity, they hand you this thick stack of legal papers, and they just walk away. You look down, and it's a summons and a complaint. You are being sued by a debt collector.
And, the immediate reaction for most people in that exact situation is just a mix of intense anxiety and, total paralysis.
Oh, absolutely.
The legal system is incredibly opaque from the outside, so the natural instinct is often to just shove those papers in a drawer and, hope the problem somehow resolves itself.
Which is literally the absolute worst thing you can do.
Yeah.
So today's deep dive is designed to completely dismantle that paralysis. We are working through a really specific stack of source materials today. We've got the Florida Rules of Civil Procedure, Title 15 of the Florida Statutes, which covers debt collection, and some landmark appellate case law, like Wells Fargo Bank versus Morcom.
That's a big one.
It really is. Plus, we're looking at practice guides designed specifically for self-represented litigants. Our mission today is to extract exactly what a person with no legal background needs to know immediately, like right now, to fight back and protect their livelihood.
Because understanding the underlying mechanics of these rules, it changes the dynamic entirely. Now, I should clarify, we are not providing direct legal advice here.
Right.
Anyone in this situation should really consult a legal aid attorney or a self-help center. But we are going to break down the what, the how, and the why of Florida civil procedure.
Yeah.
Because when you understand how the machinery of a lawsuit actually operates, you realize you are not powerless.
I always look at being served with a lawsuit like being unexpectedly shoved onto a field in the middle of a sports game, like a game that's already in progress.
That's a great analogy.
Right. You can't just stand there on the turf holding the ball, complaining that you didn't ask to play. You need to know the rules immediately. Because if you don't engage, the opposing team scores by default.
And the first rule of this particular game actually has nothing to do with the debt itself, or even whether you owe the money.
Wait, really?
Yeah, it is entirely about the calendar. In civil litigation, time is the single most critical factor. The clock starts ticking the literal moment those papers touch your hands.
Okay, let's unpack this because time limits are huge. The sources point directly to Florida Rule of Civil Procedure 1.140A1.
Right.
And this rule establishes a strict 20-day clock. From the date you are served, you have exactly 20 days to file a written answer to the complaint. You file it with the court clerk, and you serve a copy on the plaintiff's attorney.
And the mechanics of that 20-day window are completely unforgiving.
Like zero wiggle room.
Zero. If day 21 arrives and there is no answer filed in the court docket, the plaintiff doesn't even need to go before a judge to strike the first blow. Wow.
They simply file a motion for default with the clerk of court. The clerk just looks at the calendar, sees no response, and enters a default ministerially.
And a default means you have effectively forfeited. Right. The court just accepts all the factual allegations in the debt collector's complaint as true.
Exactly. It leads directly to a default judgment, meaning the debt collector wins the lawsuit automatically.
Just like that.
Just like that. You lose the right to present any defenses, you lose the right to argue about the amount owed, and you lose the chance to force them to prove their case. The game is over before you even put on your jersey.
Which is terrifying. But calculating legal days is notoriously messy in practice. So let's say I'm served on a Tuesday. Do weekends count in that 20 days?
Yes, they do.
Okay. What if there's a federal holiday in the middle of those 3 weeks? Or consider substitute service. What if I'm, out of town in Orlando for work, and my roommate is the one who actually opens the door and accepts the papers from the BSO deputy? So substitute service is incredibly common. And it's perfectly legal in Florida, provided the person accepting the papers is 15 years of age or older and actually resides in the same household.
Okay, so the roommate scenario counts.
It absolutely counts.
Yeah.
The clock starts running for you the moment your roommate is served. As for the calculation, like I said, weekends and holidays do count toward the 20 days.
Right.
However, under the rules of computation, if that 20th day happens to land on a Saturday, a Sunday, or a legal holiday, your deadline rolls over to the end of the next business day.
which highlights why guessing is just a terrible strategy here.
Yeah.
The sources are so adamant that a self-represented person must immediately verify the deadline.
You really have to.
You look at the date on the process server's return to service affidavit,
Yeah.
and you verify your math. Call the court clerk or go to a self-help center. Don't just assume you know when day 20 is.
Exactly. Assuming the clock is managed, the next phase is filing the actual answer. And a written answer isn't just, a letter to the judge saying, hey, I can't afford to pay this right now.
Right, that's not going to cut it.
No, it is a formal legal pleading. You must admit or deny the specific allegations in the complaint. And crucially, you have to assert your affirmative defenses.
Okay, so an affirmative defense basically says, even if everything you claim in this lawsuit is true, you still cannot win because of a specific legal barrier.
Precisely.
And one of the most impenetrable barriers in Florida law is the statute of limitations.
It's a huge one. The legislature sets strict temporal limits on how long a party has to initiate litigation. In Florida, if the debt is based on a written contract, which covers the vast majority of credit card agreements, personal loans, auto loans, things like that.
Basically everything most people deal with.
Right. For those, the creditor has exactly 5 years to file the lawsuit.
Okay.
If it is an oral agreement or an account stated that isn't based on a signed written instrument, that window shrinks down to 4 years.
But the vulnerability here seems to be when that timer actually starts.
Yeah.
I mean, I can easily imagine a debt buyer who purchases a portfolio of 10-year-old debt arguing that the clock should start today.
Oh, they try.
Because today is the day they so-called discovered the account or acquired the rights to it.
They do try, but the courts do not allow that kind of manipulation. The statute of limitations clock is triggered by the date of the breach.
The breach, okay.
Yeah, and in the context of consumer debt, the breach is the date of the default, meaning the day after you missed your last required payment and the account went into arrears.
Oh, so it's tied to my action, not theirs.
Exactly. It has absolutely nothing to do with when a third-party debt buyer purchased the account or when they finally decided to process the paperwork. If 5 years have passed since that specific date of default, the debt is time-barred.
It's a complete shield.
It is.
But the sources highlight another major vulnerability for the plaintiffs, and it centers on who is actually filing the lawsuit. Because often the name on the summons isn't the local hospital or the bank where you originally opened the credit card.
Right. It's rarely the original creditor.
It's some company like Midland Funding or Portfolio Recovery Associates, entities you have literally never done business with.
This brings us to a really important concept called standing.
Standing.
Yes. Standing is a fundamental legal principle. It requires the plaintiff to prove they have a direct, tangible stake in the litigation. So in a debt collection context, they must prove they actually own your specific debt at the exact moment they file the complaint.
And if I know I owe the money, doesn't anyone have the right to ask for it? Like, why does standing actually matter, practically speaking?
Well, this raises an important question about how the industry operates, because the mechanics of the modern debt buying industry rely heavily on bulk transactions. Debt buyers purchase defaulted accounts in massive portfolios.
We're talking thousands of accounts.
Tens of thousands, bundled into a single spreadsheet, bought for absolute pennies on the dollar. And when they execute these sales, they use really broad forward flow agreements or generic bills of sale.
I was analyzing the appellate decision in Wells Fargo Bank versus Morcom, which is heavily featured in our source deck. And the facts there are fascinating.
It's a textbook example.
Right. The bank was trying to enforce a debt, but the documentation they provided to prove they owned the note was incredibly vague. Basically, they get a piece of paper from the original bank that essentially says, we hereby transfer 10,000 accounts to this buyer.
Yes.
But it completely lacks any specific exhibit or addendum naming the individual debtors or their specific account numbers.
Right. So how can a court verify ownership if the plaintiff's own documentation doesn't even identify the defendant's specific account? In that Morcom case, the appellate court ruled that generic blanket assignments are insufficient to establish standing.
They need more.
Much more. The plaintiff must present a clear, unbroken chain of custody. They need the specific assignment or an allonge.
Wait, what's an allonge?
It's basically a piece of paper attached directly to the original note. And that paper clearly links their corporate entity to your specific debt. If they cannot produce that specific linkage, the court can dismiss the case entirely for lack of standing.
So by filing an answer, raising the statute of limitations, and demanding strict proof of standing, a self-represented person forces the debt buyer to do actual legal work.
Exactly.
which completely disrupts their high-volume, low-effort business model.
It really does.
But let's pivot to the darker side of the source material. Suppose a defense fails on its merits, or the defendant simply misses that 20-day window we talked about, resulting in a default judgment. We need to look at what a judgment actually does.
Okay, so a judgment is a formal decree from a judge validating the debt. It is the court officially declaring that you owe a specific amount of money to the plaintiff.
And these things don't just go away.
No, they don't. In Florida, a money judgment is remarkably durable. It lasts for 20 years. Now, you do have 10 days to request a rehearing and 30 days to appeal, but generally speaking, that judgment is sticking around.
And I tend to view a judgment not as some magically funded check. It's more like a 20-year hunting license.
That's a really good way to put it.
Because the judge doesn't transfer funds out of your checking account on behalf of the creditor. The judgment simply grants the creditor the legal authority to use state power to go hunting for your assets.
And the primary weapons they use for that hunt are wage garnishments and bank levies. To do this, they use a document called a continuing writ of garnishment.
The functional difference between garnishing wages and levying a bank account is staggering when you look at the mechanics. A wage garnishment acts almost like a leaky faucet.
Right.
The creditor serves this writ directly to your employer's payroll department.
And the employer is legally obligated to respond to it. They have to begin withholding a non-exempt portion of your disposable earnings before the money ever even hits your paycheck.
Wow.
And because the writ is continuing, it stays in effect indefinitely. It just keeps siphoning off a percentage of every single future paycheck until that entire 20-year judgment is satisfied.
A bank levy, on the other hand, operates more like a bucket scooping water out of a pool. The creditor serves the writ on your bank, and the bank must instantly freeze and capture whatever non-exempt funds are sitting in the account at that exact millisecond.
Just a snapshot in time.
Right. It doesn't automatically attach to deposits you make the following week. They would actually have to serve a brand new writ to get that new money.
But having your wages seized at the source is financially devastating, especially for someone trying to maintain housing and feed dependents. Recognizing this, the Florida legislature created a really potent statutory shield.
This is Florida statutes, section 222.J1, universally known as the head of family exemption.
That's the one.
It is designed specifically to prevent creditors from pushing working families into total destitution. Let's walk through the mechanics of who actually qualifies for this.
The threshold requirement is financial support. If you provide more than 1/2 of the financial support for a child or another dependent person, you meet the legal definition of a head of family.
Okay, more than half. And the strength of the shield depends heavily on how much money you make, specifically looking at a metric called disposable earnings.
Right. Disposable earnings are your take-home pay, but calculated in a very specific legal manner. It is the amount remaining after deducting legally required withholdings.
Legally required being the operative phrase there.
Yes.
This means federal income tax, Social Security, and Medicare. It does not include voluntary deductions.
Yes.
So if you are putting 10% of your paycheck into a 401k or paying into a voluntary health savings account, the court actually adds that money back into the calculation to determine your true disposable earnings.
Exactly. Once that baseline is established, the math is pretty straightforward. If you are a head of family and your disposable earnings are $750 a week or less, your wages are 100% exempt from garnishment.
100%.
The creditor cannot touch a single cent of your paycheck.
Even if your disposable earnings exceed that $750 weekly threshold, the shield remains incredibly robust.
It really does.
For a family making over that amount, a creditor still cannot garnish those wages unless they can produce a very specific written waiver signed by you where you explicitly agreed to wage garnishment when you originally signed the contract for the debt.
And let me tell you, such waivers are practically non-existent in standard consumer credit card agreements or medical debt paperwork. The practical result is that for a true head of family in Florida, wages are almost entirely insulated from garnishment.
But protecting the paycheck at the employer level is only half the battle, right? Once that protected paycheck is directly deposited into a checking account, doesn't it just become general funds?
You would think so.
Yeah, it seems like it would be highly vulnerable to that bucket scoop bank levy we just discussed.
What's fascinating here is how the statute anticipates that exact vulnerability. Section 222.11 includes a tracing rule. The head of family protection does not evaporate the moment the money hits the bank.
Oh, wow.
The exemption follows the money. It protects those funds in your bank account for up to 6 months, provided you can trace the funds back to your exempt wages.
But tracing commingled funds sounds like an accounting nightmare in reality. So suppose I deposit $2,000 of perfectly exempt head of family wages into my checking account.
Okay.
The next day, I deposit a $200 birthday check from my grandmother into the exact same account. I have now mixed exempt and non-exempt funds. Does the contamination of that $200 destroy the shield for the entire account?
No, commingling does not automatically nullify the exemption under Florida law. However, the burden of proof rests entirely on the debtor. You must trace and positively identify which specific dollars are the exempt wages.
Meaning you can't just walk into a courtroom and say, "Trust me, Judge, that's my paycheck."
Yeah.
You need to provide the granular evidence.
You really do. You need comprehensive bank statements, payroll receipts, and an application of standard accounting principles. Often something like a first in, first out, or lowest intermediate balance calculation.
Sound complicated.
It can be, but you have to demonstrate to the court that the frozen funds originate directly from your protected labor. And the procedural window to do this is extremely tight.
The sources indicate you typically have just 20 days after receiving the notice of garnishment to file a formal, sworn claim of exemption with the court, which is what triggers a hearing.
Right.
If you fail to file that paperwork, the shield drops. The bank turns the money over to the creditor, and it is gone permanently.
Gone. Up to this point, our entire analysis has been defensive. Navigating timelines, asserting shields, and demanding proof.
Yeah.
But the source materials also provide a powerful offensive weapon for consumers when the debt collection industry crosses the line from aggressive to just abusive.
This brings us to the Florida Consumer Collection Practices Act, or the FCCPA. It is Florida's localized, highly specific regulatory framework governing exactly how debt can be collected within the state.
The FCCPA is structured around a definitive list of 19 prohibited practices. These are bright-line rules that anyone collecting a consumer debt must follow.
And the prohibitions are highly specific. Like, a collector cannot simulate the legal process.
Right.
They can't send you a letter that is designed to look like a court summons when it isn't.
Yep.
They cannot communicate with your employer about the debt before they actually have a judgment. They are barred from disclosing information about your debt to third parties like your neighbors or extended family in an attempt to shame you into paying.
They are also restricted from communicating with you at times known to be inconvenient, such as the middle of the night, or using profane, obscene, or threatening language.
Here's where it gets really interesting, though. Most people who research debt collection harassment immediately stumble upon the FDCPA, the Federal Fair Debt Collection Practices Act.
Sure.
But there is a massive jurisdictional difference between the federal law and our Florida statute.
The federal FDCPA is remarkably narrow in its application. It generally only regulates third-party debt collectors, the agencies hired to collect on behalf of someone else, or the buyers who purchased the defaulted portfolio.
Right.
It explicitly exempts original creditors. If the original hospital or the bank that issued your credit card is the one calling you at midnight, the federal law largely gives them a pass.
But the Florida law removes that loophole entirely. It does. The FCCPA applies to almost anyone attempting to collect a consumer debt in the state. The original creditor, the third-party buyer, the local dentist's billing department, they are all equally bound by those 19 prohibited practices.
And when you have overlapping state and federal laws, friction is inevitable. Florida statutes, section 579.552, handles this through a supremacy clause.
Okay, how does that work?
It mandates that if the federal law and the state law conflict, the courts must apply whichever provision is more protective of the consumer.
Which is huge. And the enforcement mechanism for the FCCPA is what really gives it teeth. It's not just a list of suggestions for them to follow. It creates a private right of action. If a collector violates even one of those 19 rules, a consumer can file a lawsuit against them.
The damages model is quite robust, actually. A plaintiff can recover actual damages, meaning any quantifiable financial harm caused by the violation. But even in cases where the consumer suffered no direct financial loss at all, the statute allows the judge to award statutory damages of up to $1,000 per violation.
And perhaps the most vital component here is fee shifting.
Oh, yes.
If you win an FCCPA claim, the debt collector is ordered to pay your court costs and your attorney's fees.
Which changes everything.
Completely. This is precisely why consumer protection attorneys are willing to take these cases on contingency. The self-represented litigant suddenly has access to specialized legal counsel because the offending debt collector is the one footing the bill. You just have to be mindful of the statute of limitations, which gives you a 2-year window from the date of the specific violation to file your claim.
The landscape of debt collection litigation is heavily tilted, but it relies so much on an information asymmetry, they expect you not to know this stuff.
Exactly. So let's synthesize the crucial mechanics we've extracted today. When a process server hands you a lawsuit in Florida, the 20-day clock is the absolute priority. Do not ignore it, or you surrender to a default judgment.
Scrutinize the complaint for substantive defenses. Calculate the date of your last payment to see if the 5-year or 4-year statute of limitations has expired. Force the plaintiff, especially if they are a third-party debt buyer, to prove their standing with a specific chain of title, not just some generic bill of sale.
And if a judgment is entered, understand the mechanics of garnishment and immediately assess your eligibility for the head of family exemption. If you provide more than half the support for a dependent, you have a statutory right to shield your wages and your bank account, provided you act within that 20-day window to file your claim of exemption.
Finally, monitor the behavior of the collectors. If they utilize deception, harassment, or improper communication, document the violations. The FCCPA holds every collector, including original creditors, accountable, and provides a direct path to litigation and statutory damages.
I want to leave you with a final thought to mull over, looking at the macro level of this entire industry. Our sources indicate that up to 90% of debt collection lawsuits end in default judgments.
90%.
9 out of 10 people simply fail to file an answer within those 20 days. If the default rate is genuinely that high, consider the possibility that the entire multi-billion-dollar business model of third-party debt buying isn't actually based on the legal validity of the debt at all.
Right.
It might rely completely on the statistical assumption that you do not know your rights and will not participate in the process. They purchase these massive portfolios for pennies on the dollar, banking entirely on your absence from the playing field. By simply learning the procedural rules we unpack today, by filing an answer, asserting a statute of limitations defense, and raising your statutory shield, you aren't merely protecting your own bank account. You're actively disrupting the economic foundation of their entire system. The next time that heavy knot comes at the door, you'll understand exactly the mechanics of the game they are trying to play, and you'll have the tools to fight back.